I think it's good to go. It's 10.
All rise. We will obey. Please be seated.
Good morning, Madam Presiding Judge. Can you hear and see us now?
Yes, I can hear and see you.
Okay, then we are,
We shall
yes, we are
we
good.
shall now continue hearing the prosecution's response to Mr. Mladić's appeal. Madam Prosecutor, you have 1 hour 36 minutes of time allocated to your responses. You may proceed.
Thank you, Madam Presiding Judge. Before the break, I set out a roadmap of 4 arguments that I'll address in relation to the murder operation. Turning to the first, Mladić claims that there was no common plan to execute the men and boys because there was no evidence that he held a meeting during the night of the 11th to 12th of July. But the prosecution never claimed that a specific meeting occurred, and the trial chamber never found that such a meeting happened. Nothing turns on whether a specific meeting took place. A JCE does not require a meeting or even an express agreement, as the chamber correctly recognized in paragraph MICT-13-56-A, it only requires a common objective that amounts to or involves the commission of a crime. And what we know from the evidence is that by the morning of the 12th of July, the common objective included the plan to murder the Bosnian Muslim males. We know from the evidence that by the morning of 12th of July, all of the relevant military and police leaders were preparing for the murder operation. Outside the Hotel Fontana on 12th of July at 10 a.m., just prior to the third meeting, Momir Nikolic and JCE members Lieutenant Colonels Popovic and Kosaric were discussing where the men should be executed. Not whether, just where. Popovic confirmed that all the Balias should be killed. And the evidence proved that others in the chain of command, such as Yankovic and Blagojevic, already knew of the plan on 12th of July. And inside the Hotel Fontana that morning, Mladić announced that the men would be separated out from the rest of the civilian population, ostensibly to be screened for war crimes. A screening that never systematically happened, that only served as a justification for their separation. Any pretense that this separation was for screening was quickly disproved. Many of the boys and men taken into detention were too young or too old to be realistically screened for war crimes. And you cannot screen for war criminals if you confiscate and burn the detainees' identity papers, or if you order your soldiers to stop registering the detainees. And we know that the murder plan had been formed by the morning of the 12th of July from the killings later that day in Potocari and from the coordinated killings that started the next day and continued thereafter. Carried out by different military and police units, all under Mladić's command. The trial chamber found that the murders were systematic, that the men and boys were, quote, slaughtered in carefully orchestrated mass executions. Paragraph 3042. We know some of the details about this coordination from the few survivors, the men who hid under dead bodies, pretending to be dead themselves, and then lived to tell us what happened. The sheer scale and logistics of the massive and systematic killing operation prove that there was a plan that was managed from the very highest levels by Mladić himself. And Mladić's actions to shield the crimes from detection show that he approved of the plan. On the 13th of July, Mladić gave an order to keep the media out of the area, to keep the media from knowing what was happening in Srebrenica. Paragraph 5117. And it's the timing of this order that makes it remarkable. 13th of July, 1995, was 2 days after the military takeover was complete. It was the day that the forcible transfers of 25,000 civilians were complete. And it was the day that the orchestrated killing operation began. That killing operation was the primary activity of the Serb forces in Srebrenica from the 13th onward. And this is what Mladić concealed from the media with this order. And he also actively lied to the media and to international authorities to keep them away. And Mladić's reaction to the atrocities counters any argument that he was not involved in the plan. He praised his subordinates, paragraph 4290. He never punished them for their actions, paragraph 4968. And instead, he devoted further VRS resources to cover up his crimes. And as I explained yesterday, in reaching its conclusion that the JCE's objective had expanded to include the killings, at least by the morning of the 12th of July, the trial chamber was entitled to rely on evidence concerning events before and after the night of 11th and 12th of July. And I would again refer your honors to the cases I mentioned yesterday in Slobodan Milosevic and the Perlic appeals judgment, amongst others. Mladić cannot show error in the chamber's conclusion that a decision had been taken by the morning of the 12th of July to murder the men and boys. And I would note here that the video recording of a chamber staff member offering his personal views, which are not part of the record, does not shed any further light on this topic. Mladić's second claim is that he lost control of his forces when he was in Belgrade from 14 to 16 of July 1995, at most a 3-day period. The trial chamber carefully considered this argument and persuasively rejected it, devoting 25 paragraphs to this topic. Mladić calls this an alibi, but the chamber was correct to find that it was not. As we've already mentioned, the murders started on the 12th, with the large-scale organized murders on the 13th. While Mladić was in the area and in contact with the prisoners, before Mladić left for Belgrade on the afternoon of the 14th. But whether he was in Srebrenica or Belgrade, Mladić remained commander of the main staff. And the evidence proved that even when he was in Belgrade, Mladić was still actively giving instructions and issuing orders that were implemented, and that he took measures to ensure their implementation. He continued to communicate with his command staff. He continued to receive reports from the field. He held meetings with Slobodan Milosevic and international authorities concerning the events in Srebrenica and the situation of the captured men and boys and the captured UN soldiers, the UN peacekeepers. But more importantly, Mladić's leading role in and criminal responsibility for the crimes in Srebrenica and in other components of this case was not premised on his presence at each crime site. Mladić's personal involvement in the Srebrenica crimes is revealing and exceptional because it goes far beyond a normal command scenario, and it goes far beyond what is required for his criminal responsibility. And his absence from Srebrenica for 3 days does nothing to diminish his responsibility for these crimes, especially since the murders began while he was in Srebrenica and continued after his return from Belgrade. Mladić shows no error. Turning to my third argument, Mladić shows no error in the chamber's careful treatment of Momir Nikolić's credibility. Nikolić was a participant in the events, an accomplice witness. And following the relevant jurisprudence, the chamber approached Nikolić's evidence with great caution, but it found it to be, quote, generally credible and internally consistent. at paragraph 5304. The chamber was entitled to do so. Mladić fails to show that no reasonable trier of fact could have reached this conclusion. And the chamber did not err by considering an investigator's notes from a plea bargain negotiation with Momir Nikolić. Remember, Your Honors, that it was Mladić who called this investigator as a witness, and it was Mladić who tendered this exhibit for admission. It's Exhibit D1228. It was not an ICTY Rule 92 bis or TER document admitted in lieu of oral testimony, and it was admitted without any restrictions as to its use. And remember that Mladić asked the chamber to rely on the content of this exhibit in his final trial brief, for example, at paragraph 2887, and his closing arguments, transcript 44798. And he continues to ask you to rely on this document for the truth of its contents in his appeals brief at paragraph 632, footnote 772. In any event, he fails to cite to any actual finding of the trial chamber that rests on this evidence. Mladić fails to show that the trial chamber erred in its cautious and careful assessment of Nikolić's evidence. Finally, Your Honors, the trial chamber properly evaluated the status of the victims of the Srebrenica killings. The defense has argued that the trial chamber erred in finding that all of the victims were civilians. But this misstates the chamber's finding. For Mladić's individual criminal responsibility for each of the murder incidents, the trial chamber found that the victims were not actively participating in the hostilities at the time of their death. Paragraph 3062. It did not find that all of the victims were civilians. It even acknowledged that it was unclear whether some of the victims were civilians or combatants. But for those incidents, it found that the victims were detained by the Bosnian Serb forces at the time that they were killed. So they were, in technical terms, hors de combat, or out of combat. And persons who are hors de combat may not be legitimately killed. Their killings are murder. And when there was any doubt, then the chamber excluded those deaths from the conviction. And I would refer you, for example, to paragraph 2660 of the judgment, where the chamber considered evidence of dead bodies along the column's path. The defense shows no error in the trial chamber's careful and conservative approach to this issue. To conclude on the murders, Your Honors, none of Mladić's various arguments show any error in the chamber's conclusions. To succeed, he would have to convince Your Honors of an impossible conspiracy involving a complete breakdown of the chain of command, where rogue elements in the army and police and civilian authorities conducted a highly complex, massive, coordinated killing operation without Mladić's knowledge or involvement. But this hypothetical conspiracy cannot explain the extensive and coordinated involvement of many different military units and resources, all under Mladić's overall command, all reporting to Mladić. This includes the police forces that were resubordinated to him for this important operation. And it also includes what my learned friend has referred to as the security chain of command, which the record proves was subordinated to Mladić. His conspiracy claim cannot explain the repeated references in the evidence to, quote, the boss, end quote, supervising the crimes. The trial chamber rightly concluded that these were references to Mladić, paragraph 5002. It cannot explain his rallying cries for revenge, his threats that the Muslims could vanish or disappear, or his bragging that they would have disappeared long before if it had not been for the involvement of the international community. Paragraph 5128. Conspiracy cannot explain that Mladić did nothing to punish the direct perpetrators and their superiors who, under his control, conducted the operation. It cannot explain Mladić's praise for his soldiers in the conduct of this operation, even after the world understood that this was a genocidal massacre. And it cannot explain Mladić's participation in the concealment of these crimes by issuing orders to exclude the media or lying to international representatives. Nor can it explain Mladić's involvement in the cover-up, devoting military resources to rebury the bodies in order to hide the crimes. Mladić cannot show any error in the chamber's conclusions about his leading role in and his responsibility for the murder operation. Your Honors, based on the evidence showing his extensive involvement, the chamber correctly found that Mladić shared the intent for the crimes and that his contribution was so instrumental that without Mladić, the crimes in Srebrenica would not have been committed as they were. Paragraph 5098 of the judgment. In conclusion, Your Honors, none of Mladić's arguments show any error in the chamber's analysis of Mladić's criminal responsibility in Srebrenica. And for these reasons, and those set out in our brief, ground 5 should be dismissed. And with that, Your Honors, I'd like to turn over the podium to my colleague, Ms. Goy.
Good morning, Your Honors. I will address grounds 1, 2, and 9 of the prosecution's response. For the remainder of the grounds, we rely on our brief. Starting with ground 1. The indictment put Mladić on notice of all charges. In relation to the crime base, it set out the material facts, the locations, the time frames, the victim groups, the perpetrator groups, and the ways the crimes were committed. The case law is clear. In cases of massive crimes, pleading requirements for high-level accused who are not the physical perpetrators are less specific in relation to the crime base. The ICTY Appeals Chamber in Shinovic and in Krona-Jelac, amongst others, acknowledged this in light of the sheer scale of such crimes. I refer, Your Honors, to the Shinovic Appeal Judgment, paragraph 233, and the Krona-Jelac Appeal Judgment, paragraph 132. And the indictment made clear that the charges against Mladić were not limited to the incidents set out in the schedules A through G. Each time it referred to schedules, the indictment used the word including. In his appeal, Mladić does not challenge the indictment as a whole or all incidents that are not listed in the schedules to the indictment. Mladić seems to acknowledge that not being contained in a schedule does not, as such, mean insufficient pleading. For instance, Mladić does not challenge all incidents of plunder he was convicted of, although none of them are listed in schedules. Rather, his appeal is limited to 39 unscheduled incidents, for which he claims he was not put on notice. These 39 challenged incidents form only a fraction of Mladić's conviction on the relevant counts. Therefore, even if Mladić were to succeed with this ground of appeal, the conviction on all counts would stand, and so would the sentence of life imprisonment. In any event, Mladić's arguments under this ground of appeal should be rejected. Not only did the indictment put Mladić on notice of the material facts, for all but 3 of the challenged incidents, he was put on further notice through other pleadings, in particular the prosecution's pretrial brief and the Rule 65 TER summaries. These are the summaries of what each witness on the prosecution's witness list was expected to testify about. Your Honours will find the details in relation to every challenged incident in the table in paragraph 20 of the prosecution's response brief. Any potential vagueness of the indictment was cured by this additional information about these incidents. Mladić himself acknowledges that notice can be provided through an announcement in the summary of witnesses' evidence in the so-called 65 TER filings. Even on Mladić's own argument, many of the challenged incidents were properly notified, since they were contained in the 65 TER summaries. Now refer Your Honours to paragraph 15 of the prosecution response brief. In her argument in court yesterday, my learned friend Ms. Baggott made a distinction between the incidents that were specifically labelled unscheduled incidents in the Rule 65 TER filings and those where this term was not used. The defence seems to have withdrawn the appeal with regard to incidents where the Rule 65 TER filings used the words unscheduled incidents. And I refer Your Honours to the transcript from yesterday, pages 22 and 23. This withdrawal seems to cover at least the following 4 incidents. Srebrenica Incident V of the 18th of July 1995. I refer Your Honour to response brief footnote 68. Sniping Incident O of the 10th of December 1994. Refer Your Honours to the response brief footnote 106. And the 2 shelling incidents I and K on Getiova Street of the 22nd and the 28th of June 1995. And I refer Your Honours to the 65 TER witness list at page 230, paragraphs 7 and 8. So we understand from the submissions Ms. Baggott made yesterday that these incidents no longer form part of the appeal. And I note here that in other filings, the prosecution also explicitly referred to a number of challenged incidents as unscheduled incidents. I refer Your Honours to the prosecution motion for judicial notice of adjudicated facts of the 9th of December 2011, Annex C pages 220 and following. Your Honours will find the specific references in the table in paragraph 20 of the prosecution response brief, and to the Rule 92 bis motion referred in footnote 80 of the prosecution response brief. But even when the filings did not use the words unscheduled incident, they put the accused on sufficient notice. Some incidents are described in the prosecution's pretrial brief. Again, Your Honours can find the references in the footnotes to the table in paragraph 20 of the prosecution response brief. For others, the Rule 65-ter summaries themselves provided further notice. From the enumerated paragraphs of the indictment to which the summaries refer, and from the text of the summaries, it was clear that the witness was not only going to testify about scheduled incidents. These summaries indicate that the particular witness's evidence, in addition to scheduled incidents, will also address other specific incidents not covered by the schedules, even though the summaries did not explicitly use the term unscheduled incidents. There is no requirement that the prosecution uses the words unscheduled incidents.
Ms. Goy, could you kindly pause? We've lost one of the
Yeah.
judges, so we'll try to reconnect. Thank you. Madam Presiding Judge, I'm informed that we have reconnected with Judge Ngum.
I can't hear you.
Madam Presiding Judge, I'm informed that we are now established connection with Judge Ngum, so we can proceed.
Thank you. Madam Prosecutor, you may proceed.
Thank you very much. I was saying before we were disconnected that there is no requirement that the prosecution uses the words unscheduled incidents. Even the Chamber's Rule 73 bis D decision of the 2nd of December 2011, to which the defense refers to in its appeal brief, does not support this proposition. It does not require to use the term unscheduled incident. But more importantly, as the disposition on page 4 shows, that decision relates only to incidents which the prosecution proposed to remove from the schedules, not those that were never included in the schedules. To sum up, even if the pleading in the indictment was too vague, the table in paragraph 20 of the prosecution's response brief shows that Mladić was on notice of these challenged incidents. In any event, the burden is on Mladić to show prejudice, and he has not done so. The burden is on him because in general he failed to raise the question of insufficient notice of these incidents in a timely manner. The first time Mladić raised this point as a general matter was 6 weeks before closing arguments, in his motion alleging defects in the form of the indictment of the 24th of October 2016. And what explanation does the defense give why it did not raise this point earlier? Why it did not object every time the prosecution was introducing evidence that the defense thought did not relate to the charges in the indictment? The slide. I'm waiting for a slide. The defense said that it, quote, did not systematically respond to evidence it considered, based on the Chamber's guidance, extraneous. It is not the defense's role to encourage the prosecution to sharpen its case and use its time effectively, end quote. That's from the defense motion for reconsideration of the 7th of December 2016, paragraph 9. This strategy is of course one that the defense can choose, but there is a serious risk involved. The risk is, if the defense does not object to the admission of evidence that goes to an incident which the defense claims it is not sufficiently notified of through the indictment, in case of conviction, the burden to show prejudice on appeal shifts to the defense. And I refer your honors to the Nietegeka appeal judgment of the ICTR, paragraphs 199 to 200. To avoid the burden shifting to the defense, the objection must be timely. If the defense does not object at the pretrial stage through a motion challenging the indictment, the defense must challenge the admissibility of evidence in a timely manner, such as at the time the evidence is introduced or through a timely motion to strike the evidence. Here, the defense admits that it did not systematically object when the evidence was introduced. Rather, it waited until 6 weeks before closing argument before it filed its motion to challenge the indictment on this basis. The ICTR Appeals Chamber in Bagosora addressed this situation. The situation where the notice objection is raised at trial, but later than at the time the evidence was adduced. It held that in such a case, the question is whether the objection was so untimely as to consider that the burden to show prejudice has shifted to the defense. Factors to consider are whether the defense has provided a reasonable explanation for the failure to raise the objection at the time the evidence was introduced, and whether the defense has shown that the objection was raised as soon as possible thereafter. That's the Bagosora decision of the 18th of September 2006, paragraph 45. Mladić did not have a reasonable explanation. He chose not to object in a timely manner. His argument that he considered, based on the Chamber's guidance, not to be charged with unscheduled incidents is disingenuous. The trial chamber did not give guidance that the charges were limited to scheduled incidents.
Mr. Mladić has asked that he's been expecting for some time now that the learning counsel on the other side would show what she's talking about, which she has not done. He's talking about some kind of slide. I don't know whether he's able to actually understand what is being presented.
If it would be helpful, we could maybe show the slide again with your honest permission. With your honest permission, I would proceed with the argument.
I think you can proceed. I mean, I note that it's in English and my client doesn't read English.
I have read the quote into the record, so the transcript should. But I'm happy to read it again if that is helpful. The quote says, "The defense did not systematically respond to evidence it considered, based on the Chamber's guidance, extraneous. It is not the defense's role to encourage the prosecution to sharpen its case and use its time effectively," end quote. That's from the defense motion for reconsideration of the 7th of December 2016, paragraph 9. The guidance Mladić is referring to in the quote is the Chamber's Rule 73 bis D decision of the 2nd of December 2011. The decision in which the trial chamber adopted the prosecution's proposal on the reduction of the indictment. This decision only reduced the number of scheduled incidents, as well as 2 municipalities altogether. But it did not limit the incidents in the retained municipalities to scheduled incidents only. The trial chamber itself confirmed this in a decision on the 23rd of February 2017. It said, the Rule 73 bis D decision, quote, fixed the number of scheduled incidents, but did not affect other incidents within the scope of the indictment, which remained part of the indictment as charged, end quote. That's paragraph 11 of that decision. And the trial record shows that throughout trial, Mladić did not believe that the charges were limited to the scheduled incidents. And I would just like to highlight a few occasions. On 16 December 2011, 2 weeks after the Rule 73 bis D decision, the prosecution filed the fourth amended indictment, which implemented that decision. This fourth amended indictment retained the word including whenever it referred to incidents in the schedules. The word including shows that the indictment was not limited to those schedules. And Mladić did not bring a preliminary motion to challenge this fourth amended indictment at that time. Mladić's conduct during trial further demonstrates that he knew the charges were not limited to scheduled incidents. Mladić cross-examined prosecution witnesses on unscheduled incidents, and Your Honors will find the reference in the table in paragraph 20 of the prosecution response brief. And when Mladić challenged the inclusion of the unscheduled sniping incidents in the prosecutorial bar table motion, his complaint was rejected. The chamber noted that the indictment specifies that the incidents and schedules F and G to the indictment are illustrative examples of the acts of shelling and sniping underlying these charges. That's the decision of the 28th of January 2014, paragraph 10. And during the defense case, Mladić asked his own witnesses about unscheduled incidents. For example, he asked his own expert witness, Zorica Subotic, to address unscheduled incident G. Kobaya Street of the 16th of June 1995. I refer Your Honor to transcript page 39546 and following. Why would Mladić have done this if he did not think these incidents formed part of the charges against him? And Mladić specifically defended against a number of challenged incidents, as can be seen from the table in paragraph 20 of the prosecution response brief. This means Mladić was aware and was told during trial that the indictment was not limited to scheduled incidents. He therefore could have and should have objected at trial each time he thought the prosecution was introducing evidence in relation to events not covered by the indictment. He did not do so, therefore the burden to show prejudice is on him. Mladić did not show such prejudice. He cannot. He was not prejudiced. Ground 1 should be dismissed. I'm turning to ground 2. Mladić fails to show error in the trial chamber's use of adjudicated facts. ICTY, ICTR, and mechanisms jurisprudence have carefully struck a balance between using adjudicated facts in the interest of expediency and the procedural rights of the accused, including the right to confront one's accuser. Generally, facts can be proven solely through adjudicated facts, even those facts that relate directly or indirectly to the guilt of an accused. This has been recently confirmed by the Karadzic appeal judgment in paragraph 121. To protect the rights of the accused, there are 3 important limitations to the use of adjudicated facts. 1, they cannot be relied upon to establish acts conduct, and mental state of the accused. 2, they can be rebutted. And 3, taking judicial notice in any event remains within the trial chamber's discretion. The trial chamber in this case was mindful of these limitations, and Mladić's attempts to show errors fail. First, Mladić does not show error in the trial chamber's use of adjudicated facts concerning the conduct of Mladić's proximate subordinates. Second, he does not show that the chamber applied the wrong test when determining whether an adjudicated fact was rebutted. And third, Mladić fails to show error in the trial chamber's treatment of adjudicated fact 1476.
Ms. Goy, could you kindly pause? We've lost one of the judges again.
Yeah.
Madam Presiding Judge, we're ready to reconnect. We can proceed.
Thank you. I was just giving Your Honours the roadmaps of the 3 points I was going to make, and maybe it's best that I just repeat this list. So first, Mladić does not show error in the trial chamber's use of adjudicated facts concerning the conduct of Mladić's proximate subordinates. Second, he does not show that the chamber applied the wrong test when determining whether an adjudicated fact was rebutted. And third, Mladić fails to show error in the trial chamber's treatment of adjudicated fact 1476 in relation to Srebrenica. I will address these 3 points in turn. Mladić criticizes the trial chamber for having taken judicial notice of adjudicated facts relating to the conduct of Mladić's proximate subordinates, as this would be, in his view, a short step to prove Mladić's criminal responsibility. But he fails to show cogent reasons to depart from established jurisprudence that the only areas that are excluded from the adjudicated fact regime are the acts, conduct, and mental state of the accused. There is no reason to reconsider the decision rendered by the ICTY Appeals Chamber in this case. The relevant acts and conduct of the accused, which are excluded from adjudicated facts, in a JCE case like this one, are the accused personal contributions to the JCE. The Mechanism Appeals Chamber in Karadzic recently addressed this in a case where, as in this case, the physical perpetrators were used as tools by the JCE members, including a high-level accused. It found the trial chamber did not commit an error by taking judicial notice of the existence of crimes committed by Karadzic's subordinates. It recalled the distinction between facts going to the conduct of the physical perpetrators and those going to the conduct of the accused himself. It held that what is excluded from the adjudicated fact regime are facts that showed that the accused engaged in the required actus reus. The Karadzic Appeals Chamber, however, expressly acknowledged that the trial chamber has discretion to take judicial notice of facts relating to the conduct of other JCE members and the conduct of physical perpetrators of crimes for which the accused is criminally responsible. That's the Karadzic Appeal Judgment, paragraph 121 and 122. Mladić fails to show that the trial chamber abused its discretion in taking judicial notice of the conduct of other JCE members or physical perpetrators who were his proximate subordinates. That other trial chambers exercised their discretion differently does not show that this trial chamber abused its discretion. In particular, Mladić fails to show that this was a short step for the chamber to prove Mladić's contributions to the JCE. Mladić argued in paragraph 91 of his appeal brief, and again before Your Honours yesterday, that adjudicated facts regarding acts of his proximate subordinates contributed to the chamber's finding that he made a significant contribution to the JCEs through his command and control of the Serb forces. But he does not demonstrate that the short step concern arose in his case. He does not show that any adjudicated fact of conduct of his proximate subordinates was used by the trial chamber to establish Mladić's JCE contributions or his mens rea. His argument should be dismissed. Your Honours, I'm mindful of the time, and before turning to the second part of the submissions on ground 2, I wonder whether it's best to break now.
Yes, you have only 2 minutes to the break time. I suppose it would be a good time to break, and we resume at 13:10 Zambian time. Rise.
All rise. We will obey.